All right, guys, so let's take a look at the groups. I'll share that part of the screen with you at this point, and we'll just verify that everybody is in a group. Okay, so this is what I shared with everybody this afternoon. So hopefully you saw this. All right, so this is everybody in the class list with a couple of exceptions. So I'm not quite sure one or two people are actually still in the class, but this is what we have at this point. So we have 6 groups with 6. One group has 7 in it. The topics are those that we're covering over the course of the semester: criminal justice, law, land and treaties, missing and murder, Indigenous women and girls, family violence, residential schools, and environmental issues. All right, so everybody is in a group, or you should be. If you're not, please let me know, and I'll make sure that you are in a group. But at this point, I believe everybody is. If you want to change groups, and you're welcome to do that, please do it, in the next few days. If you are going to change, please let the group which you are leaving know that you are leaving, and the group to which you are joining, let them know. All right. Anybody have any questions about the groups? All right. So what's really important, and I mentioned this last day, for the purposes of the groups, what I want you to do, these are the broad topics that you all have. So amongst yourselves, think about something that is significant to your topic. All right, a particular person or a particular event that you can focus on that is much more particular than just the broad topic that you're dealing with. All right, and so again, the whole point is that when you do the presentations in front of the class and myself, which is the last class that we have in April, you'll be imparting knowledge that we wouldn't necessarily have simply as a function of talking about the topic more generally.
Dean, I'm in
All right,
class.
so that's the
Please
purpose.
stop.
All right, so and in that
Oh,
regard,
I'm
in the
sorry.
next few weeks, when you get to a topic, please tell me what it is. All right, when you've narrated it to a person or event, please tell me what it is, and we can take it from there. I just want to make sure that you're on the right track. All right, so that's it for the groups, unless anybody has any questions. Okay, so next item is the discussion. I posted last week the video. It's a documentary, actually, a point of view documentary by CBC on Colonization Road. So does anybody have any discussion points you want to make? Put up your hand with respect to what you saw in that video. So obviously this is the purpose of this, is to get you to participate. All right. So anybody? Ursula?
I just wanted to make the comment. I was like blown away by the fact that former Harper said that there's no history of colonization in Canada.
Right. Yeah, you know what, I didn't, and I'm a political junkie, so I watch these kind of things. I didn't know he'd actually said that. It's whoever, to whatever audience he was speaking to, I
Yeah,
did not know that was coming, and that really, really surprised me.
yeah. I was like really taken back by that.
Yeah, me too. Me too.
It just shows the lack of like what he's putting out there to the Canadians that are not aware of the history of Canada and its relationship with the First Nations people.
Yeah, and I got the impression that that speech wasn't necessarily to Canadians, because I think most
Okay.
Canadians would recognize that he was totally wrong. I think that was probably to the United Nations or to a
Okay.
G7 conference, to some conference internationally where they wouldn't necessarily question him on what is
Okay.
obviously an erroneous statement. But absolutely, that's good pointer. So thank you,
Yeah.
Michelle. Your hands up.
Yeah, I was just surprised to see that there's still so much discrimination and racism, especially in Canada. Like, I just think that, there's Canada's, in my opinion, a mixing pot of all different kinds of people. And I'm myself don't notice, and I don't, to me, it doesn't matter who's Métis status, non-status. Like, I just can't believe that this continues to go on in this day and age.
Oh, absolutely true. And I think the national consciousness is certainly elevated with respect to Indigenous issues. It certainly has been in the last 10 years. The Idle No More movement, the blockades, the Mohawk blockades last year, dealing with the Chilcotin Indigenous rights in British Columbia, those kind of things. They were in the news, at the top of the news hour all the time. So I think you basically have to live in a cave to avoid them. But so I think it's much more evident and obvious to people who live in this country who follow news, whether it's actually regular news like TV or radio or social media. I think that it's hard to avoid it. But yeah, it absolutely still exists, and there are people who are in fact racist, and some of them proudly so, which obviously is a real problem. Rainbow.
Well, I just wanted to say I thought it was like a super well done video. One thing that really did catch me off guard too was that little clip about Stephen Harper. But I kind of had the same thought process as Ursula, that if our prime minister is saying stuff like that, it just, I feel like it doesn't really reflect well on Canada's history. And it's something that I was actually speaking about as well. It kind of was shocking to me, because I'm an Indigenous person and I'm from Sault Ste. Marie, so it's kind of shocking to me that I didn't really know, a lot of people didn't know about residential schools and Canada's history. So that, I don't know, that was just one thing that I thought about.
No, I appreciate that. And I said this in a previous class. When it comes to political parties and how they approach Indigenous issues, the Conservative Party of Canada has always been difficult, right? They've and Stephen Harper was a Conservative. They've always put up a wall with respect to how much they would acknowledge with respect to Indigenous issues. Although Harper did make an apology about residential schools in 2008, although he didn't do it in the House of Commons, which is where it was requested to be done. And so, we'll see that. And Justin Trudeau being a Liberal, they traditionally, over the course of time, have been more receptive to Indigenous issues. So we'll as we study this over the semester, we'll see that dichotomy between, however you lean politically and how you feel about these kind of issues, because there really is a difference. Carolina?
Yes, I found the Road to Freedom part really interesting, and the Shaw Lake, the created nightmare of no water supply, that was really touching for me as well, eye-opening. And I also found the parts about generally the roads being built as the colonization went on, that they were poisoning the land, all the reference to that. Very interesting, very interesting. And further, I found the main person who was the author of the video, I guess, the comedian. I found some of his points quite, they got me thinking, saying such things as, are you leaving? When are you leaving? Or even the older woman at the end of the video stating, if you step on my feet, if you get off of them, I'll forgive you, but you're still on them.
Right.
I just found a lot of different concepts that I never thought about.
Yeah, no, it was well done. Thank you. Elizabeth.
Yeah, so along the lines of kind of what she just said, I think the whole situation with the road access and Freedom Road not being able to be built for as long as it was, and then it was finally built in, I think it was 2019, it was the grand opening of it. And I think the fact that a community like that was denied access to so many different things, because it wasn't just about water, it was access to healthcare, it was access to food, access to everything. And that was baffling that because I obviously it happened, I think everything started going on 2015, 2016. So at that point in my life, I wasn't really paying attention to politics or human rights or any of that, but it's crazy that it wasn't bigger than it was. I think that in terms of something like that happening, that's a huge human rights issue. So for the fact that it wasn't as publicized, or as, I think it should have been a lot bigger. So the fact that I just think that's crazy that went on.
You're absolutely right, and what we'll also see, and it really does depend on geography, is that while movements like Idle No More, which started in Ottawa and spread across the country, gathered attention, the thing with the Chilcotin tribes last year gathered attention. The problem with the Shoal Lake Road, and I had actually never heard about it, and and which is a surprise because I try to keep track of this stuff, is because it was in around the Winnipeg, Manitoba area, right? And Winnipeg, Manitoba, which has the highest concentration of Indigenous Canadians in an urban setting in the country, is a very racialized city. It's incredibly racialized. So, I think to your point, Elizabeth, the fact that it took place in a community that had no desire to make it public, what they had done, the expropriation of 3,500 acres and cutting off road access to the Shoal Lake First Nation, the fact that they would keep that quiet because they had no desire to make it public plays into it. Right, so it's not only these things not only are national and provincial issues, but they come down to actually where in the country do they take place? Do they take place in somewhere where people will pay attention? So obviously, I Don't Know More started in Ottawa. That's a very good place to start a movement because there's so much reporting that takes place there, versus someplace like Winnipeg, which is highly racialized and has no desire to make these things public. So that's the kind of stuff we'll see as we go through the rest of the semester as well. Okay, Farhang.
I was reading through the claim filed to the Specific Claims Tribunal in 2019 by Shoal Lake 40 and Iskate Mozajdian 39, and in the section of funding, it says that they were having a hard time funding their participation towards the negotiations. And I was wondering, is this normal for it to be the tribunal to be inaccessible to people, or is it just because of the special situation of Shoal Lake 40 that they're not able to get the funding they need?
The Specific Claims Tribunal? No, and we're going to talk about this later in the semester. The comprehensive claims and specific claims tribunals are there for complaints that First Nations have for breach of treaty rights. Comprehensive claims are like British Columbia, where there are no treaties to a great degree. So for specific claims, there actually is funding available to First Nations to put their claim forward. So I'm surprised that there would be an issue with that. But but everything turns on the facts. So there obviously was some issue with respect to accessing the funding, and I'm not aware of that. But if you've read the tribunal decision, then you know more than I do, Farhang. So good for you.
Yeah, I think. Sorry to interrupt you. On top of what you're saying, it says that this claim is that while they want to move forward with this claim as expeditiously as possible, the challenges associated with the claimant's access to funding support from Canada has impeded progress on the negotiation of this claim. So I think Canada wasn't really giving that.
And that's a shame because it's the federal government, as a function of the Constitution that we all know now, has the authority, has responsibility in the jurisdiction to provide for that kind of thing. That's the level of government that has to provide it. So if the federal government is dragging its heels on providing funding for litigation, then yeah, it's their fault. Lyndon.
So in the video, I found it interesting or unique that when the comedian visited the shop where the printing was occurring, I believe it was like kind of selling Canada, and the way that they were promoting Canada at the time was through, here's all the farmland that you'll receive, the plot of land that you'll receive when you come here, but not promoting anything in winter and the 8 months out of the year that you'll not have access to water or anything. So I kind of just saw that as basically another lie that the government was telling to promote people to come to Canada.
Oh, sure it was. I mean, when it's like anything, they're marketing a product. So, anybody who markets a product, and we're talking about something that took place 150 years ago, but anybody who markets something, you're going to accentuate the positives, and they had all kinds of nice little graphics about how welcoming it looks like it's going to be. The fields are plowed, there's little villages existing, those kind of things. Well, that wasn't the case at all. It tended to be open fields. It was obviously Indigenous territories that was acquired as a function of treaties. That's what happened. So it certainly wasn't plowed fields. There weren't any existing villages. It was open unplowed fields, because most Indigenous peoples who entered in the treaties and went on to reserves weren't farmers. They were hunters and gatherers, right? That wasn't what they did. So yeah, it was misleading from the get-go. But once you leave, Eastern Europe or the United Kingdom, you put your money together You get on this ship, you travel for 3 weeks across the ocean to get here, and then you somehow get transportation, I presume by train, to get from, from Halifax where you arrive to somehow get to, what was, what became Manitoba, Saskatchewan, Alberta, and that's not going to be by train necessarily until the 1880s when McDonald finished the railroad. Once you get there, you have 160 acres, which is what you're promised. And it's yours, and it's yours as in we're giving it to you. You're going to do what you can to live on it. It's much more than you had when you left the old country, and it's what you have here in this new country, and you have no option to do anything else, right? There's you don't show up on this parcel of land. 160 acres is a large chunk of land. It's again, I told you this last week. A standard farm in Canada is 200 acres, but 160 acres for whatever reasons what they chose to give settlers. It's still a chunk of land. It's like you would be hard pressed to see the borders of your property, standing on a flat piece of land. So, to walk away from a gift, which this was, just because it doesn't look like the pictures you were told or what the flyers said is going to be, is a pretty difficult proposition. And so I have no idea what the statistics are on those people who may, in fact, have turned around and went home. But I'm guessing pretty much nobody, turned around and went home once they were actually here. So again, that kind of promotion got the people here, and then their circumstances made them stay. All right, Dalpinder.
Hi. The point I want to make is like it was like so kind of like surprising because as Canada have like a pretty good reputation like all over the world, and especially like when it comes to like international students, it's like a more kind of safety and security you feel about like racism in Canada. Like okay, there's like no discrimination and no racism. I mean that like that's true for today, but like kind of like how in the past like it was like so much like the First Nation people like suffer so much like so hard from like even from the same community people, but that's good. Like with the time it's like how like people change and like their thinking, all like kind of like it was like such a big difference when you look like today's society, and then like to that people who is like open the like schools and everything like yes to like like totally destroy like one kind of entire culture. So that's what I feel when I watch the video.
Sure, thank you. Very, very good. Thank you. Emily.
So I just wanted to say that watching this video was just this, I don't know, I just found it like eye-opening, and like I'm almost embarrassed to be white. is that a bad thing to say?
Not at all, no.
It's just disgusting to me that there's still like we're still in today's society honoring these colonizers by like having streets that were named after them still in their name, like Yonge Street in Toronto, or the statue of Egerton Ryerson. He was like a supporter of residential schools. It's still up in Toronto. So yeah, I just wanted to say that.
Yeah, and we talked about that before too. I mean, especially regarding all the buildings with Johnny MacDonald on them, right? And
yeah,
and statues that are taken down with respect to that. Michelle, next again.
Yeah, my question was regarding the Royal Proclamation, and I was just wondering, how come back when King George wrote the Royal Proclamation, he wrote in the Royal Proclamation that they wouldn't treat with Métis because they were considered half-breeds, and King George didn't feel that Métis had inherited rights over the land. So I'm just curious, because I kind of studied that before, and I'm just curious, where did the Métis fit in with that if King George himself said that he wouldn't treat with them in like back in the day?
Okay, we're gonna talk about that during the class, right?
Okay.
When we go through the historical progression. So sit tight, and when we get to that point, put up your hand again, Michelle, and we'll cover
Thank
it
you.
more. That's fine. Ava.
I was just kind of concerned with. I'm sorry. Someone said they were ashamed to be white. I get that there's colonialism in the past and history. I just don't understand why that would mean you're ashamed to be of a race that just so happened to have also done that. Because everywhere across the entire globe throughout history, almost every single country has, committed atrocities against other ones. I just don't see why shaming an entire race, generations after that all happened would make any kind of progress. That seems to me like it would just, I don't know, seem like too much. It's just too much to me.
I understand what you're saying, and it's a bit of a conundrum, but it's a phenomenon that happens a lot. And it's there's two sides to the coin, and it's a very legitimate position to take. The one position is that, and we'll talk about white, the dominant society was white in Canada, and it still is to a great degree, and that it creates the need to apologize for things that have taken place in the past, and that's why Stephen Harper apologized for what happened in residential schools in 2008 for the schools that existed before that. And Justin Trudeau has apologized for a number of things, including turning back a shipload of Jews at the beginning of the Second World War. They wanted to have asylum from Germany, and we turned them away, right? And again, history is a very subjective thing. It's a fine line that we have to draw, because you have to remember, and we'll talk about this tonight some more, and look at the past. I mean, when we get to residential schools, and more than that, I mean, white colonialism, the whole purpose of it was, from the white person's point of view, was that they thought that they were genuinely doing these savages, and that's a very derogatory term, but it's what was used, doing Indigenous Canadians a favor by making them more white, by making them, again, assimilate into Canadian white society. And
I'm sorry. I do completely understand, but I'd like to make the differentiation between Harper and Trudeau apologizing on behalf of the Canadian government and the wrongs that they have done, versus saying that the entirety of the white race is guilty of something that my ancestors, maybe not even my ancestors, because my family came here after all that, but everyone who seems to be lighter of skin tone is now being put into this categorization of being colonialists, and that we're basically just the same person as back then, and we need to apologize for our ancestors. And I feel like that is not going to make people, like, for example, everyone in this class already, I assume, already acknowledges the tragedies of the past, and we know that that is wrong. But if you're talking to someone who isn't convinced of that, by saying that white people are wrong, oh, they're all terrible, they're all colonialists, that's only going to make someone who's racist more racist, I find, or at least I think that that would do that. But in this class, I feel like it should be more of a general, this is what happened in history, but not so much that white people are the devil because of what happened in history with this particular British French colonialist group.
Well,
that's how
I totally get what you're saying, and you're totally entitled to that. This is, we're in a university setting, so this is the place to have this kind of constructive discussion. But I mean, we're going to come across this a lot, because a lot of the systemic racism that took place that results in the incredible deprived socioeconomic status of Indigenous Canadians and their overrepresentation, for instance, in things like the criminal justice system, is a function of white racism. And the fact that we acknowledge it doesn't mean that you personally have to take that into yourself as a personal apology. You had nothing to do with it personally, and I totally get that. But there's no way in the world that we can avoid making a point that the white dominant society in Canada over the course, and this is around the world for the most part, did some things that were incredibly detrimental to other human beings, and we have to acknowledge that. And it's not racist to say that that saying that paints all white people with a brush. It doesn't. It just acknowledges a white dominant society that did things that by today's standards are unacceptable. But that goes back to what I said earlier, is that again, history is subjective, right? What white people did, and this is in Canada now, but in most colonial governments and dominions, what white people did at the time, they thought they were doing it for the betterment of the people that they were basically paternalizing, right? And that's what they thought they did, and the governments that they elected, perpetuated that because they thought that's what the people wanted. Having said that, again, because it's subjective, well, we're entitled to look at that and say, you know what, that was a really crappy thing to do, and that's putting it pretty lightly. But it's not racist for us to say we did or didn't do it and to acknowledge it. We have to acknowledge it because it is historical, right? And we learn from it. And yes, Trudeau and Harper do apologize for these things. They don't. They do it on behalf of the Canadian government. The Canadian government is heterogeneous. It's not homogenous any longer, right? So it's the Canadian government today is made up of a lot of races and cultures and ethnicities, and that's who they're apologizing for. But they're still, to the great degree, dealing with actions by a dominant white society, and we're just not going to get around that, right? So that's where we are. And it's still. I mean, if you're, and this is, I don't know anybody here who may be German, but if you are German and you have a German background in this country, right, and anywhere in the world, there is an amazing and exorbitant amount of shame truly these days, no matter how productive Germany is, for the Second World War. There are still people who suffered as a function of what Germany did in the Second World War to Jews and Polish people and a number of races, but primarily Jews. And they still feel shame about it. They didn't do it. There's very few people still alive who actually participated in it. But as a German people, they acknowledge that that's what they did, and they learn from it. And there's no way to get around that. It's a human nature to accept responsibility for what's happened, even if it's your ancestors or even if it's just your race that's done it. So we will come back to this on a regular basis, and we're not going to do it in an apologetic kind of way. And there was exceptional white racism in this country that primarily affected Indigenous Canadians, to a lesser degree Black Canadians. We're going to accept it, acknowledge it, and learn from it. And that's what being in a university class is all about. But Ava, you're entirely entitled to your opinion. Carolina.
I just wanted to answer to the point that Ava is bringing up. It's totally understandable that the generation that started the whole dominion of Canada is not responsible anymore for it, and we live in modern times. But I think the shame the person was mentioning comes more from being human and all the equalities and rights that we've been taught so hard. And this brings me to the point to say that Canada was meant to be equal, and that's why the shame arises, because everything we stand for was not met. It is still not being met. My daughter is Métis. My husband was born in Botswana, and he's still unable to obtain status because his parents passed away. I am clearly involved in reading about this stuff. And I think that the shame wasn't for all white people. And, I look white, but I'm from Poland. So most people refer to me as Eastern European. That separates the white people as well. So it's just such a deep subject, and there is no perfect thing, but they were definitely suffering. There's no doubt that the land was taken away for the reason of the market and the commerce. This was the selling point, the key point. So it is shameful that it happened either from white people, anybody. It's just shameful human nature.
Yeah,
that's how I would see it.
And in those circumstances, are we gonna call each other names, right? Again, this is a really useful conversation to have, and we're going to engage in it, and we're going to engage in it every class that we have for the rest of the semester, because we're dealing with how Canadian laws and policies affected Indigenous persons, and you can't avoid it. All right, so that's fine. Matter of fact, I've taught this course 4 or 5 times. This is the most in-depth conversation I've had with a class on this issue. So, Ava, thank you for the conversation and thank you everybody for contributing to it, right? It's the kind of thing that I really, really would encourage in a class in a third and fourth year, law and justice and political science class. So good for you. That's why we're here. Elizabeth, your hand is up.
Yeah, I just want to say, like, I say this with the most respect that I can say this with, but I think that approaching Indigenous issues with the mindset that, like, it wasn't our generation who did it, so it's not my problem, is a little problematic, in the fact that, truth and reconciliation still needs to be happening today. And if we have the mindset of, like, it wasn't me or my ancestors even, that, like, it shouldn't concern you, like, I think it should be everyone's problem. And I think everyone should feel connected to this, not even if it isn't necessarily them being treated that way, because if even if you aren't Indigenous yourself, like, you can still play a part in making things better for other people. And I don't think that feeling bad about other humans being treated a certain way because of people of your race, like, I think I don't know, I think that approaching it from an aspect of, like, wasn't my generation, I shouldn't deal with it, is, I don't know, I just think that's, I don't know, not good.
No, I get that. Again, I'm really, really pleased with the level of engagement you guys are doing, and this is really super. And I will not at any time ever, stop somebody from expressing an opinion, because I want your opinions. So, we've got 50 items in the chat. That's astoundingly great from my point of view as a university professor. So I'm really, really pleased. But I'm going to have to now turn to the lectures. So we had half an hour of a really good discussion. So thank you all very much. If we could do this every class, I'd be thrilled to death. But okay, so tonight we're going to do the lectures, and we're going to be covering two topics. The one from last week, which was human rights. We didn't quite get to finish it from last day when we were dealing with the Constitution. So just so you guys have a handle on where we're going for the next few weeks. So tonight we're doing human rights, and then I'm going to follow up with governance and creation tonight. All right, hopefully finish that in a decent time. Right, there's quite a few slides, and then we have breakout questions tonight. You guys all have those on Moodle, so hopefully you're ready for that. Next week is our reading week, so there isn't a class, so that's fine. Do with it what you will. The following week is our midterm exam. All right, so I've posted the details of that on Moodle. So it's going to be midterm exam. It's going to be sent to you in a Google form. It's going to be a combination of true and false and multiple choice questions. There'll be 70 of them. All right, I'm going to give you an hour to answer that. And then it's going to be open book, right? So, and they're going to be drawn from your materials. So, the readings, primarily my lectures, the PowerPoint slides, basically, and including videos we've watched. So that's the content you're going to be responsible for the midterm. And then after the midterm, and that's all we're going to do that class. There's not going to be a lecture afterwards. The following week, which is March the 1st. So honest to God, we're flying through the semester. We'll be on residential schools. That'll be the next topic after tonight's topic. All right. Any questions about any of that? Where we're going? Okay. Again, if you have any questions as you get ready for the midterms or what have you, send me an email and I will definitely get back to you as soon as I can. All right. So you're welcome to do that virtually anytime. Okay. So tonight we're going to talk about the protection of human rights. Again, this follows up on last day, our review of the Constitution. All right. So, because we are a British colony, when we first became a country in 1867, we didn't have any human rights legislation, built into the British North America Act, which we adopted. Right? There wasn't anything along those lines because Great Britain didn't have human rights legislation or codes of conduct either. All that Great Britain had was its common law being laws decided by judges, passed around amongst judges for the purposes of applying to the country. So, at the time of Confederation, we had unwritten individual rights that were based upon longstanding traditions and practices. Right? As time passed, however, human rights and discriminatory practices in Canada grew to become unacceptable, right? And the first one that became pretty clear right off the hop, and this is a function of Johnny MacDonald again, was the Chinese head tax. So I may have talked about this briefly before. Anybody want to give us a quick synopsis of what the Chinese head tax was? Any hands? Okay. So what happened is that, again, we talked about this before. So John A. and the boys decided to build, a railway across, the country from ocean to ocean, essentially, to enable the settlement of the prairie provinces. Right. That was the whole deal with respect to creating this country, to create this new market for those in the provinces who were manufacturing bases, basically. And as a function of promising to create this new country, McDonald said, look, I will tie the country together with a railway. It makes it, available for settlers to settle the new territory that we're going to acquire from indigenous peoples who are already there. And it gives us the ability to move goods back and forth. Obviously, it's commerce, right? Making money. And so he did that. And it took 20 odd years from Confederation to the mid 1880s to do that. In order to build the railway, McDonald recruited Chinese immigrants to come to this country to build it for virtually nothing. They were paid like absolutely pennies on the dollar, and even the wage for a British subject in Canada at the time was no more than 25 cents a day. That is, in the 1930s, my father made $1 a day during the Depression. So this was 60 years earlier than that. So I can't imagine what anybody who's working in the regular scheme of things was making. But I guarantee you the Chinese were making monumentally less than anybody else. So he built the railway on, to a great degree, slave labor. And then when the railway was finished, right, you had thousands of Chinese immigrants who had basically immigrated to Canada, were living in Canada, and they wanted to bring their families to Canada to build a life because this is where they decided to live. And McDonald's policy was, well, we just don't want that. We don't want these people to bring their families here. So we put a head tax in place. The head tax was $50, $50. So $50 in 1885 was a monumental amount of money. I mean, I can't adjust it for inflation, but I guarantee you it was tens, if not hundreds of thousands of dollars in equivalent currency back in 1885. So it virtually was an incredibly racist policy to keep Chinese out of Canada. And that was put in place in 1885 and, recognized fairly soon thereafter how, in fact, racist that was. Carolina, you had a hand up?
Yes, I just had a question. Besides the head tax, was there no any other in law descriptions of the Chinese population? Because I remember I was reading something in another course. At that time, they were also referred to as people that weren't capable of certain things. Their capacity wasn't recognized.
One of the exactly, thank you. One of the things that became part of the popular culture at the same time as the head tax, and it's all propaganda, mind you, was that they tied in the Chinese people, their culture, with opium addiction, right? And this is particularly in British Columbia, where there was a lot of Chinese because that's where the railway ended up being finished. And so what happened was that to basically create an environment where the Canadian public would accept this kind of thing without any question, really, was by painting Chinese people as being subhuman. That they spent all their times in these opium dens, and there were a lot of cartoons and newspapers that portrayed that these are the kind of people that these are the kind of people they are, and why would we want more of their kind to come here? Okay, so that's kind of what happened there. So you're absolutely right, Carolina. So thank you for that. All right. So again, it was levied in 1885 to stop basically Chinese immigration from coming to Canada. It was done at the completion of the railway. So it was done basically after the railway was done. So we don't need these people anymore. And again, the fear that was generated was the opium trade to substantiate this incredibly racist policy. Right? The next major racist policy, this is of the Canadian government, mind you, was with the treatment of Japanese Canadians during the Second World War. All right, now again, and I mentioned this briefly too, remember the Second World War, right? And again, it's way beyond any of your memories and probably even beyond your grandparents, but my father was a veteran. I can tell you that the Second World War, you had Allied powers and the Axis powers. So the Allied powers were Great Britain, Canada, the United States, Australia, New Zealand, and Russia, right? And that's really important. And they were fighting the Axis powers, which was Germany, Italy, and Japan. And one of the things, again, has happened in British Columbia, where there was a lot of Japanese that had settled. These were Japanese Canadians. These were people who were actually born in Canada and were citizens of the country. But what they did is a function of the fear of them being related to those who were our enemies during the war. They put them in internment camps. And they basically confiscated all of their property, which included all of their real estate. Eventually, again, there was an apology not that long ago, within the last 20 years kind of thing, and a formula to pay them for some of their lost interest in property, but it certainly was nothing compared to what the property is worth today. But it was recognized that, you know, how the Canadian government, you know, treated its own citizenry during the Second World War was seen as a real problem from a discrimination point of view. All right. Clearly, and again, this is the topic of this course, you know, likewise, the colonialism and assimilation, fundamentally residential schools, and systemic discrimination and racism that, you know, that the dominant white society imposed upon the Indigenous peoples over the course of the time that, you know, from British to the colonial government to the Canadian government and forward, has always been an issue of discrimination that, you know, that most Canadians recognize now as something that, you know, needs to be addressed. Right. So what happened is, this is after the Second World War, is that most provinces began to take on the position that they should protect human rights. And you remember the division of powers between the federal government and the provinces. Both levels of government had the authority to deal with this issue. This is like taxation. You know, nobody said to the other level of government, you can't get involved in, you know, protection of human rights. But if you do, it has to be within your sphere of authority. So in the 1960s, most provinces decided to put human rights legislation in place, right? And they did it based on race, religion, and ethnic origin, right? So some fairly fundamental grounds of discrimination, right? And they did it in things that they were allowed to within the provincial sphere of authority. So remember, as we talked about when Confederation came about, things in the provinces that the provinces kept power over were things of mostly a local or personal nature, you know, language rights and what have you. It also included things like labor. We talked about that. Labor was a provincial responsibility, and accommodation. So if there was a human rights discriminatory matter that dealt with restaurants, hotels, living accommodations, apartments, employment and wages, then that was something that the provinces assumed authority over to enact human rights codes, right? Over the course of time since then, this was the 60s, human rights codes, which we have in every province and territory in Canada, have expanded their grounds. So it now includes things like sexual harassment, sexual identity, and what have you, again, dealing with things that are provincial, so workplaces and accommodation. In Ontario, we have an Ontario Human Rights Code. RSO stands for Revised Statutes of Ontario. 1990, that's a citation, right? We haven't revised our statutes since 1990 for one very simple reason. They were revised up until 90 every 10 years, and that's because they were written, as in hard copy written. And so every 10 years, the government of Ontario would collect, you know, the statutes from 1980, add all the new statutes together and put them into what were called Revised Statutes of 1990. But what happened between 1990 and the year 2000 is that laws were become digitized and went online. So there was no longer any need to basically take all the laws subsequent to 1990 and put them into a hard copy and bind them into a revised format. So basically any laws that existed in 1990 that still exist will still have that citation, RSO 1990. But now you can go online to any number of databases, both provincial and or legal databases that you have access to. And you can see the laws that are in effect as of today, without a lot of in-depth research, which is a really good thing. But that's explaining why, you're going to still see a lot of statutes that say RSO 1990 because they haven't needed to be basically physically updated since that date. These are the grounds, and you think about these grounds because we're going to come across these grounds in other spheres as well that we're going to talk about right now. But here are the grounds that we now have in the Ontario Human Rights Code. So you can't be discriminated against on the basis of age, ancestry, color, race, ethnic origin, creed. Anybody know what creed is? It's a form of religion. Disability, family status, marital status, gender identity, gender expression, the receipt of public assistance, or sexual orientation. So, you know, these last ones dealing with gender identity and expression, what have you, they weren't in the first Ontario Human Rights Code in 1960. Those weren't issues that were on anybody's radar back then, but certainly in the last 20 years, they have been. And that's why the Ontario Human Rights Code has been updated to include these more current grounds of discrimination. All right. And again, their discrimination is protected in areas of accommodation, employment services, and things like labor and labor unions. All right. Ontario Human Rights System has three components to it. You have the Human Rights Tribunal of Ontario, the Human Rights Legal Support Center, and the Ontario Human Rights Commission. Those are three very separate, basically, bodies that are important for the purposes of enforcing human rights. The tribunal is where you would go, and I believe one of the questions, the breakup questions last week dealt with this, and the group answered it quite correctly. The Human Rights Tribunal is where you go if you actually have a complaint, right? So if you think your rights have been violated, and it's going to be one of those enumerated grounds of discrimination we just saw, if you think you've been discriminated against based on one of those grounds of discrimination in the fields of accommodation or employment or what have you, then you call the tribunal and you say, I think I have a complaint. Can you confirm that for me? And they will do that. So they're very good about that. So they'll decide the best way for you to proceed. If they don't think that your rights have been violated, then they will in fact tell you why and where perhaps you could go otherwise to take care of it. So they may say, you know what, because you've been discriminated against with respect to a Canadian labor union, right? Not a provincial one, but a Canadian one. They probably say you should probably proceed with a complaint under the Canadian Human Rights Code, all right? Or if the Canadian government or the provincial government has harmed you, it's not going to be a Human Rights Code violation, it's going to be a charter violation. So these are the kind of things you have to be aware of, all right? The second body that deals with human rights in Ontario is the Human Rights Legal Support Center. This kind of operates as a legal aid center for those seeking to process a human rights complaint. So it provides legal assistance to those who can't afford to do it. So they assist in that way, which obviously is a really important thing to do. And then lastly, you have the OHRC. This is the policy-making body of human rights in Ontario. So this commission is basically where those members of the commission decide what will be the grounds of discrimination in this province. So it would have been this commission that decided over the course of the last 20 years that we're going to add protection against gender identity, gender expression, discrimination on those grounds. We're going to add those to the code, right? So it's a policy-making body. In 1977, the Canadian Human Rights Act was passed. So this is about 15 years after most provinces and territories did, which again, it covers pretty much the same kinds of areas of discrimination that we just talked about, but it deals with those people who have been discriminated against within the federal jurisdiction, the Canadian government, basically. All right, the Canadian Bill of Rights, incredibly important. All right, so at the time that the provinces were thinking about putting in place their own human rights codes of conduct and what have you, the federal government was thinking about it too. And this was a function, again, in the 1950s of recognition of what the federal government had done in the past. Again, think back, it was only a decade previously that we had the internment of Japanese Canadians, right? We put them in camps because they were simply Japanese, right? So it wasn't that long previous to this that stuck out as a pretty significant area of discrimination by the white dominant society. So what happened was this fellow on the left, that's Sir John, Diefenbaker, John Diefenbaker. He was the 13th Canadian Prime Minister from 57 to 63, right? He was a member of Parliament during the Second World War. So he was a member of Parliament. He was a lawyer from Saskatchewan, quite a good one from what I understand. He was a member of Parliament during the Second World War that was involved with the internment of Japanese Canadians. So, he was actively involved in that discrimination. And, human rights was a big thing for him personally. So in the 1950s, he became prime minister. He was a conservative prime minister. He took this to heart and decided that the federal government needed to do something to address discrimination in Canada as a nation. All right. So basically, what he did is he put together working groups and inquiries to do this, and he came up with the Canadian Bill of Rights, which was enacted in 1960. All right, so it took 2 or 3 years for him to do that. Canadian Bill of Rights is incredibly important. It was our first national rights instrument to a great degree, right? That was adopted in Canada for Canadians. So think about, I'm going to go through the grounds of it relatively quickly, but think about it, how it compares to the grounds we just talked about for provincial human rights codes. So section 1 of the Canadian Bill of Rights basically said that everyone should be protected against discrimination by virtue of race, national origin, color, religion, or sex. Sounds familiar, it should, right? There are going to be rights to life, liberty, security of the person, and enjoyment of property. Now, everything except that enjoyment of property should be really familiar to you. We're going to talk about that in a few minutes, but just think about, this was put in place in 1960, right? Secondly, the right to equality before the law and protection of the law, freedom of religion, freedom of speech, freedom of assembly and association, freedom of the press, right? So think about all those things. I mean, those things, should sound pretty familiar to you today, even though, the Canadian Bill of Rights is not something that anybody relies upon any longer. But this is something that was put in place 61 years ago. So just keep that in mind. What the Bill of Rights said is that it declared that all federal statutes must be construed and applied. That was both existing statutes on the books at the time and statutes going forward. That statutes basically had to be interpreted and enacted with the rights and freedoms of the bill kept in mind, right? Pretty important, right? With respect to due process, and due process is something that is there for those who are accused of crimes in the country to protect them from the power of the state. That's what due process is, and that's for instance, due process rights are fundamental to the U.S. Bill of Rights, which are the first 10 amendments of the American Constitution, put in place from 1887 for the next 30 or 40 years. All right, so just that the American Bill of Rights wasn't part of the American Constitution. They did not put it in place. The Jefferson and Washington and Madison, they did not believe that they could get enough consent amongst the states to agree to rights in creating this new country, which became the United States of America. Although the Declaration of Independence was 1776, it didn't come together as a country until 1787. So it took them 11, 12 years of wrangling amongst themselves and fighting the British to become a country the way it is now. All right, so due process, Canadian Bill of Rights, 1960, the freedom from arbitrary detention, imprisonment, exile, and cruel and unusual punishment. We're going to hear that again, right? A person who's detained or arrested has to be informed and given the reason for the arrest or detention. They have the right to retain counsel, the right before a judge within a certain time after arrest, right? A court can't compel somebody to give evidence against himself. That's self-incrimination. The right to a fair trial according to the principles of fundamental justice, the right to reasonable bail, the right to be presumed innocent until proven guilty. And I guarantee that's one right that you've all heard about, but I also guarantee you it didn't come from the Bill of Rights, okay? And that's what Diefenbaker put in place in 1960. But there was problems with it, right? Because it wasn't a constitutional document. So I didn't tell you, for instance, that what Diefenbaker did is that he went to London, right, and asked for an amendment to the British North America Act to put these rights into the Constitution. He did not do that. And as we talked about that last day, that's exactly what he would have had to do if he wanted to constitutionalize the Bill of Rights, right? It was, our Constitution at that time was still a British document. Okay. So the problem with it was that because he didn't constitutionalize it, it was only a federal statute, just like any other statute in the books, just like the Income Tax Act or the Divorce Act, right? These are acts that can be changed at will by any following any following parliament. So it didn't have the effect of being a constitutional document. It only applied to federal laws, so it didn't affect provinces or provincial laws, right? So it was very limited in that way. The federal government, any new federal government could override the statute by changing it, right? All you had to do was amend the statute, which would therefore amend the Bill of Rights. There wasn't any constitutional formula to make that a cohesive or comprehensive exercise by 7 provinces and 50% of the population, which is our amending formula, right? Again, it could be repealed by any subsequent federal legislation, and because of all of these constraints on it, judges didn't give it a lot of weight. They realized what a weak foundation it had, and so they didn't treat it like judges do today with the Charter, right? Having said that, however, the Canadian Bill of Rights is still the law in Canada. So the Charter, Canadian Charter of Rights and Freedoms, which came into place in 1982, and we're going to go through that, it didn't override the Bill of Rights, right? And what the Canadian Bill of Rights still does that the Charter doesn't do is provide the right to protection of your property. We didn't include that in the Charter. That was a negotiation between Pierre Trudeau and the provincial premiers in 1982. They decided to keep that out. So if you have a claim against the Canadian government dealing with your property where you think you've been discriminated against on any of those grounds we talked about, and it deals with the actual, your property, and your property also includes the right to earn a living, that's a property right, you still have a claim under the Canadian Bill of Rights. So it's not a totally defunct piece of legislation. All right, let's talk about international human rights, right? So these are important because these likewise, provide background to what we've done in Canada. So at the end of the Second World War, right, when all the countries, well, the Allied countries came together and decided, you know what, we have to stop future generations and future nations from doing what horrendously happened during the Second World War. Again, because we were the Allies, we pointed our fingers at Germany and Japan. What we basically said is at the end of the Second World War, we have to stop this kind of thing, right? We have to put into place something that will guide the countries of this new world going forward to ensure that this kind of discrimination is put to an end. So at the end of the Second World War, what they put in place was the Universal Declaration of Human Rights, right? Incredibly important document. It basically is the first international rights document that was enacted to be adopted by all the countries in the world. It was actually enacted in 1948, led by Eleanor Roosevelt, who was the widow of Franklin Delano Roosevelt, who was the president of the United States from 1933 till he died in office in 1945. He was elected 4 times, right? They don't do that anymore. They amended the Constitution so that couldn't happen, thank God. But he was elected 4 times during the Second World War. So the Declaration of Human Rights went into place in 48. And then what happened is at the United Nations, because it was a document of the UN, the United Nations passed 2 what are called multilateral treaties. Multilateral meaning amongst a number of countries. Bilateral is 2, multi is many, right? So they passed 2 multilateral treaties, one called the International Covenant on Civil and Political Rights, and the second one being the International Covenant on Economic, Social, and Cultural Rights. It's the first one, the ICCPR, that is the most important one for our purposes. And what Canada did in 1976, Canada and its provinces, they acceded to those covenants, which means they signed onto them and agreed to implement their terms into Canadian domestic law. And what the declaration said is this. Pursuant to Article 2, subsection 2, it said that all countries who agree to sign on to these covenants agree to do the following. They basically say, what this says is that we agree that we will put into domestic law constitutionally the terms of the International Covenant on Civil and Political Rights, which mirrors, of course, the Universal Declaration of Human Rights. So we agreed to do that in 1976, right? Here's what the covenant says, and this is going to obviously sound familiar to you because it is. So Article 6 of the covenant says that everyone has the right to life, which shall be protected in law. Everybody has the right to be free from inhuman, degrading treatment or punishment, not unlike cruel and unusual punishment, to be free from slavery. And remember that slavery term was there because it affected countries, around the globe that still in fact had slavery. We didn't. We haven't had slavery since 1834. All right. Article 9, the right to be free from arbitrary arrest and detention, the right to liberty and freedom of movement, the right to equality before the law, to be presumed innocent until proven guilty. That kind of sounds familiar, right? The right to a fair and public hearing, right? The right to peaceful assembly, the right to freedom of association. This is interesting, the right to marry and found a family and have equal rights between men and women within a marriage, okay? The right to participate in public affairs, the right to equal protection of the law, freedom of religion, freedom of minorities, culture and practice, and what have you, all right? So, you know, here are things that were in the International Covenant that became very much like what John Diefenbaker put into the Canadian Bill of Rights and what Pierre Trudeau put into the Charter, and the provinces likewise put into their Human Rights Code. So, you know, it's not that, you know, the Ontario Human Rights Code or the Canadian Bill of Rights or the Canadian Charter of Rights and Freedoms, they started from scratch and said, what should we protect, right? The Universal Declaration of Human Rights in 1948 told everybody what to protect, and then they just went about their business over the course of the next 3 to 4 decades to ensure that in fact that took place, right? One of the, now we're going to talk about the Charter, right? So the Charter comes into place in 1982, right? It's appended to the Constitution, it's Schedule B. That's a Schedule 2 to Schedule B of the Constitution, which means it's a constitutional document. So it's much more important and much more serious than was the Bill of Rights in 1960, which is merely a federal statute. So it's constitutionalized, which means all the rights in the Charter are constitutional rights and freedoms, incredibly important. It deals with issues that you would have as a Canadian citizen, and sometimes you don't even have to be a citizen, with respect to rights and freedoms affected to you by a form of government. That's going to be fundamentally the federal government or the provincial government, okay? The greatest impact the Charter had was with respect to the supremacy of Parliament. I talked about this last day, right? So when we talked about the governance of Canada and the Constitution, one of the things I talked about was basically that is both in basically the Constitution Act of 1867 and 1982 is the supremacy of Parliament, with the exception of the Charter, right? So up until the time of the Charter, the laws that were put in place by the federal government of Canada were the laws that were supreme in Canada. That's why we elected members of Parliament to go to Ottawa and make those decisions for us. But once we had the Charter, right, the Charter made sure that all levels of government, including the federal level of government, had to respect the rights and freedoms in the Charter, which means that if the federal government did something, as in it enacted legislation that did not conform to the Charter, then it was in violation of the Charter and had to be corrected for the most part, right? We talked about exceptions to that, but it had to be corrected, which means that we went from having a parliamentary supremacy to what's called a constitutional democracy. And that's what we have today. It's incredibly important to remember that. Okay, so in the Charter, here's what we have. Section 1, incredibly important. So the Charter guarantees the rights and freedoms set out in it, subject to such reasonable limits prescribed by law as can demonstrably be justified in a free and democratic society. And I talked about this last day, and it was the breakout question. What this section says is that the Charter guarantees the rights and freedoms that are in it, but there can be an override of those rights and freedoms by the courts, basically, if in a free and just society, it can be justified to be appropriate, right? And that's where we talked about somebody could be found with 3 pounds of coke in the trunk of their car. It could be an illegal search, which is contravening Section 8 of the Charter, the right to unreasonable search and seizure against that, right? So somebody can go to court, they can argue that there was an illegal search because the cops didn't have a warrant to look in the trunk, or it didn't have reasonable ground to look in the trunk, and they found the coke, and a court would then have the jurisdiction to either basically keep it out of the evidence under Section 24(2) of the Charter, we'll talk about that tonight, or it can say, pursuant to Section 1, I'm going to leave it in because in a free and democratic society, it's a reasonable limit on the Charter rights to keep that as part of the evidence, all right? Section 2, these are the fundamental freedoms: freedom of conscience, religion, freedom of thought, freedom of expression, freedom of press, freedom of assembly, freedom of association. At this point, these should all be really familiar to you because we've talked about these, you know, basically in the ICCPR, we've talked about these in the Canadian Bill of Rights. So it's not that you know, Pierre Trudeau, in 1982 created the Charter out of thin air. He took the obligations that had already been well established both nationally and by international law. So those freedoms are not absolute, however. So for instance, the freedom of expression does not allow, for instance, the publication of a belief that you believe that the Holocaust did not take place. And this is an actual case that happened in Canada. Eric Zundel was the guy who did this. He's an Albertan who published that the Holocaust was made up. It was a Jewish fantasy, basically. And he was prosecuted for hate speech as a function of that. And his defense was, well, I have freedom of expression. I can say whatever I want. And the court held, well, no, you can't. Even though you do have freedom of expression in the charter, in a free and democratic society, we don't think you have the right to particularly say that, right? So that's where hate speech is an exception to the freedom of expression. Section 3, everybody in Canada has the right to vote in an election, to vote for the House of Commons, basically for those who are qualified to run. House of Commons can't sit for longer than 5 years. We mentioned this last day. Every citizen in Canada has the right to enter, remain in, and leave Canada. All right, so again, we're talking about this and how it's on moving in and out of Canada during the pandemic, right? It's kind of important to keep this in mind because, you know, by putting restrictions on international travel coming into this country, if you're a Canadian citizen or moving between provinces, is a violation of the charter, right? So, and it's already reached some provincial courts where have held that Section 1, because of the pandemic, justifies contravention of Section 6. Okay, all right, and here again is part of Section 6. You have the right to move up and move from any province to province, right? So you can't shut down the borders of provinces, which in fact has taken place. Okay, so now we're going to deal with what are the legal rights. These are the due process rights in the Charter, which again reflect exactly what was said in the Canadian Bill of Rights, which was said in the ICCPR and in the Universal Declaration of Human Rights. So Section 7, you have the right to life, liberty, and security of the person. All right, we've already seen that. The right from unreasonable search and seizure, freedom from arbitrary detention and imprisonment. These are just all repetitions of what you've already seen. Section 10 has a lot of rights of due process in it. Section 10, you have the right to be informed of the reason for your arrest and detention promptly after it taking place. You have the right to instruct counsel without delay and be informed of that right immediately. So cops, when they arrest you and detain you, immediately tell you you have the right to contact a lawyer. If you don't have a lawyer, and you probably don't if you're being arrested for the first time, hopefully, they will point to a number on the wall in the interview room, which will be a legal aid number in Ontario. And they guarantee you, and they're absolutely right, that if you call that phone number on the wall, and the cops will leave the room when this takes place, and they won't record what goes on in the room, you can call that number. You will get a lawyer. It's likely to be a very inexperienced lawyer who still does legal aid, because lawyers with any kinds of experience don't do it any longer because it doesn't pay at all. It's very, very poor paying. But if you're a newly called lawyer, you'll do this kind of work just to make a living to start with, you will get a hold of a lawyer, right? And they will give you their opinion. So 9 out of 10 times, the question is, should I blow? And 9 out of 10 times, or 10 out of 10 times, the answer is yes, right? So that's the kind of conversations that take place when you call that legal aid number on the wall. C, everybody has the right to have their detention determined by way of habeas corpus. Habeas corpus is a very old English writ. It is the only ancient writ that survived the Bill of Rights in the United States. They've incorporated habeas corpus. We've incorporated it into the Charter, so it's incredibly important. What habeas corpus does is this. If you are arrested and you question the grounds for your arrest, as in you don't believe you should have been arrested, and the government being the police, acted improperly, you have the right to almost immediately be taken before a court and a judge and have the validity of your detention or arrest validated or questioned. Incredibly important right. It's also the first right that disappears during an insurrection or a treasonous event. So Pierre Trudeau, we saw last week about the Just Watch Me, the video we watched. One of the things he did when he put into place the War Measures Act was he suspended the rights to habeas corpus. So when he arrested all those people belonging to the FLQ that we talked about, they did not have the right to come before a court, to have their case heard immediately. Abraham Lincoln suspended habeas corpus during the Civil War, right? He did not want to limit the ability of General Ulysses S. Grant and the Union Army to capture and interrogate rebel soldiers from the South, right? They did not have, he did not want to give the Confederacy the right to question interrogations. So it's an incredibly important right, but it's the first right lost when there's questions of terrorism or insurrection. Section 11 has a lot of rights too. The right be tried basically in a reasonable period of time, the right not to be have an unreasonable delay in coming before a judge for the purposes of bail, not to be compelled to be a witness. You can't be self-incriminating in this section. Again, to be subsection D, to be presumed innocent until proven guilty. So again, we've seen that. This is now the fourth time you've seen that. So this is just a continuation of rights that are widely recognized. The right not to be denied reasonable bail. Section 12, the right not to be subjected to cruel and unusual treatment or punishment. Again, we've seen that before, right? 15 is really interesting. 15 is the equality rights section. So this is the section that is the comparator to the rights against freedom of religion and sexual discrimination, gender identity, all those kind of things. This is where it's found in the charter. And it's really interesting to see how it works because remember, this was put in place in 1982. And because it's a constitutional document, it can't be amended easily, and it virtually never has been amended. So the grounds of discrimination in 1982 were race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Nothing in there about gender identity or gender expression. It's not in the charter. However, because we have what's called a living tree constitutional process, we've touched upon this, because we grow and we see our constitution grows with the times. The Supreme Court of Canada has made it very clear that the charter is also part of that living tree. And so what it did in the early 2000s when cases came before it of discrimination based on gender identity, expression, what have you, what they basically said is we're going to look at section 15.1 of the charter and we're going to read into section 15.1 the protection against discrimination for gender identity, expression, and what have you, right? So it is now a function of the charter, not as a function of constitutional amendment, which would be the most straightforward way to do it, but a function of the case law, the common law. So the Supreme Court of Canada has expanded on the rights of equality. Okay, so that's kind of important to realize because if you were just to look at section 15.1, if you go online and you pull up the charter, you look at it, this is all you're going to see. You're not going to see any additional wording that says protection against gender identity and expression. 15.2 is a really important paragraph. This is the benign discrimination paragraph. What this, or subparagraph, and what this section basically says is this, that it's okay to discriminate against people for all those reasons that we describe discrimination to be protected from. Again, it's things that were in 15.1, discrimination based on race, sex, ethnicity, color, what have you. It's okay to discriminate, on those bases if by the purpose of that discrimination, what you're doing is you're giving an advantage to those people who have traditionally been the subject of that same kind of discrimination. Right? This is a very popular movement. It took hold in the American Constitution in the 1960s with what's called affirmative action. Anybody want to tell us what affirmative action is? It's a pretty well-known phrase. Okay, so what happened in the 1960s, the time of the Civil Rights Act of 1964, Lyndon Johnson putting in place after Kennedy was assassinated, that kind of thing. So the 1960s was a very, very active time for racial inequalities and trying to level the playing field in the US. So what affirmative action took place in the 60s and still now applies as a function of this section in the charter is this. If two people were applying for the same job and one was white and one was black and they had exactly the same credentials, right? Neither one of them had more work experience, neither one of them had better educational backgrounds than the other. It would be appropriate for the employer to hire the black person over the white person, although the white person is clearly being discriminated against on the basis of their color, right? And so what that basically says is because blacks in America, still applies in Canada, applies to Indigenous peoples in Canada, obviously, if they have been traditionally discriminated against based on these things, right? And there's an opportunity for them to be given an advantage because of discrimination over somebody who hasn't been discriminated against, white people for the most part, historically, then it's okay. That's what the charter says. It's okay to in fact do that. So that's a really important provision of the charter, and one that's used quite often. You very, very seldom see nowadays a job posting for any job that doesn't ask for if you identify as any particular group or with a disability or a discriminatory nature. They ask you for that specifically because they can take advantage of that provision. Okay. The enforcement of the charter is section 24. So all I'm going to say about this is section 24 is the section that basically says that if any of your rights and freedoms have been abridged or violated, that you use this section to get before a court to have it assessed and have your rights put forward. Right? That's section 24.1. Section 24.2 is the section dealing with basically unreasonable searches and seizures. What this section says is that if you are arrested or detained and there is any evidence of any kinds of goods or evidence per se that comes to light as a function of an illegal search and seizure, essentially, that this is the section that you apply for to keep it out of the trial record. So again, this is the section that the defense counsel would use to keep his client's 3 pounds of coke that was found in his trunk out of the evidence or the trial. Right, so that's the section that's used, and again, that's the section that is, comes under as well the purview of section 1, saying that violations can be overridden if it's appropriate in the circumstances. Right, section 25 is a charter right dealing with Aboriginal rights. Right, and it basically, again, it's a constitutionalization recognizing the rights and freedoms recognized in the Royal Proclamation of 1763. So Michelle will get to that tonight. So that's what it does. So interestingly, the Royal Proclamation put in place by King George III in 1763 is part of our charter today. Right? And we'll talk about that proclamation in a few minutes. Right? And likewise, any rights or freedoms by way of land claims and agreements, are likewise constitutionalized. So section 25 of the charter, in concert with section 35 of the Constitution, right, in light of the Indian Act and the Royal Proclamation, is what we have to look at to see what Indigenous rights are at play in any particular situation in Canada these days, right? And again, section 35, this is the Constitution, the existing Aboriginal treaty rights of Aboriginal peoples of Canada are hereby recognized and affirmed. All right, guys, so that's it for human rights. I mean, I flew through that, and I apologize because we have a lot to cover on the governance side of things. But hopefully a lot of that wasn't news for you, right? Hopefully that you knew that you'd heard about a lot of those rights and freedoms, particularly in the charter, because of all of that we just went through. Clearly, the charter rights is probably the most important part of that particular lecture. Although obviously, clearly important to keep in mind Ontario Human Rights Codes, which apply as well. Michelle, your hand is up again.
Yeah, I just had a question. We had the World War II with the Chinese and we had the head tax. And what if that sort of situation were to happen again? What if we were invaded again by China? Because I mean, look at what's going on in China right now, and with with Taiwan and the US ships sailing over there, and like, what if that were to happen now? I mean, China is communist and they're formed with Russia and I think India, right? Or is it Iran or Iraq? I'm not sure, but I mean, what would happen if we were to go to war again, just per se? I don't know, because none of us have ever been involved in a war. We wouldn't know what to do.
But we have a very recent example, one that's not that old, it's only 4 years old, where Trump in one of the very first things he did by way of executive order was stop the immigration of Arab immigrants from Muslim nations. He stopped it. Seven countries. No more. They can't immigrate to this country. Right, so there you go. I mean, it's not that this is out of the line and out of the realm of reality. It totally depends on who's in power and what power they think they can wield as a function of their elected position. Right? So Trump had absolutely no problem in a very racist position to keep those of the Muslim faith out of the United States. So he's not president anymore. So you now have Biden. I seriously doubt Joe Biden would take that position. He's just not that kind of person anymore.
But like, what if the U.S. did go to war with China again? Like, would we have the head tax again? Would we do this?
You wouldn't have like a head tax because that was just to keep immigrations out. But you could have internment.
Yeah.
But who's to say that if we went to war against any particular country, and it was a war that involved life and death, and we thought that there was spying going on internally, who's to say we wouldn't round up all, you know, Chinese people? I mean, that's a tremendous population in Canada. Round them up, put them in internment camps. Who's to say that wouldn't happen? I don't think it ever would, but you know, I think that's more realistic than not. But again, you know, you never know. It depends on, you know, who's in power at the time. Depends upon the policy of the party in power, right? That is the supremacy of Parliament, right? But which we now know, however, is subject to the Charter, right? So that kind of thing would raise Charter arguments immediately, you know, and then, you know, it's no longer the supremacy of Parliament anymore. So we do have that protection now, you know, for the last 4 years. Hope to God it's never used. But you know what? You never know. Hysteria takes place. Tremendous amounts of propaganda take place, right? Particularly when it's a war. So, you know, what we may do as a nation may be something that I have no idea we would do, you know, sitting here in front of you guys tonight, you know, in this particular time in our history, right? What's going to happen 5 or 10 years from now based on globalization and issues around the world? I have no idea. I don't think anybody does, right? It totally depends on who's in power. So good question, Michelle. It really is. But I don't have a firm answer because, you know, I don't have a crystal ball. Okay, thank you. All right, so now we're going to talk about creation and let's see now here. There you go. Creation, history, and governance. And so eventually we're going to get into the government structure of Indigenous Canadians in Canada. So we'll start with, and this is I think chapter 2 or 3 in your text, dealing with the worldview of how, you know, and this is perhaps relevant to what Michelle was saying, you know, so the worldview is a set of assumptions and beliefs upon how people comprehend themselves, you know, in the world, right? And the worldview is a function of stories and symbols and analogies and metaphors that makes up somebody's worldview. And everybody has a different worldview based upon your personal experiences that you've had, you know, basically growing up, right? And there's a worldview in Canada that's part of the dominant culture, the part of the British white dominant culture. And again, it's not so much British any longer, still to a great degree, you know, is very important, but it's still, you know, slightly more than 50% white in Canada, right? So the foundations of the mainstream Canadian view is that this country was founded on the religious creation story. Basically, we are a Christian nation. You know, there's plenty of religions in this country now that are widely recognized, and certainly, you know, in the society we have, we're a mosaic, not a melting pot. We encourage people to have their own religions, to, you know, to honor their own religions, to practice their own religions and cultures and what have you. But the dominant religion in this country is still Christianity, which includes the Catholic Church, which is you know, still dominant in the province of Quebec, and all kinds of Christian denominations, Methodists and Presbyterians, and Latter-day Saints, and gosh, there's a bunch of, and Pentecostal, right? There's a bunch, you know, in this country, and you know, they're all practicing openly without inhibition, basically. In the worldview, humans are seen to be the dominant species on the planet. Basically, we have dominion over animals, fish, birds, and what have you. A dominion, again, this is the white dominant society's purview of the world, basically. Our justice system is rooted in religion. It's not a mistake that almost everybody, when they take an oath to tell the truth in a courtroom, swear it on a Bible. Now, people don't have to do that anymore. They can simply affirm that what they're going to say is the truth. But still, the majority of people still affirm or attest on the Bible that what they're going to tell the truth in a court of law. So they're basically saying that I'm telling you this in the eyes of God. We do believe in the scientific creation story, which is obviously Darwinism, and not the creation of the earth 6,000 years ago with Genesis, what have you. There are still, you know, there's a great number of people who still believe in that, and they're welcome to their belief, but that's not the dominant belief in this country or in the United States, although in the United States, over 40% of their population are now fundamentalist Christians who believe in the book of Genesis, right? So that's an important thing to keep in mind, but that's not the dominant view in Canada at the stage of the game, right? We talked about this last week dealing with social contract. So Thomas Hobbes, political philosopher in the 16th century, believed that it was that men and women, but men came together in society before the formation of governance, and it was a brutal, that's the word he used, a brutal society where they would kill each other to survive. It's dog eat dog kind of thing. He advocated having the absolute power of a monarch and a top-down kind of government, right? And then so people agreed to that based on his philosophy of a social contract, so that they wouldn't constantly be at war with each other. They agreed to put someone at the head of the government in place who could rule over them to basically stabilize their lives for the most part. And then following that, you have John Locke. He didn't believe in the brutishness of society. He in fact believed that society was much kinder kind of thing. But he also believed that the Bible again was incredibly important, and that land ownership was essential to society. And again, a very top-down kind of thing. His philosophy of land ownership was incorporated by Thomas Jefferson into the American Constitution. Jefferson actually quoted John Locke in the formation of the Constitution, as in the right to property. Again, Canada doesn't have that, but the enjoyment of property is a constitutional right in the United States. All right. Now, the Aboriginal worldview, you got to remember these things are all very general, so this isn't specific to anybody in particular, basically. Clearly, before contact, which is when Europeans came to North America or Turtle Island, there were enormous amounts of organized Aboriginal peoples on this continent. The people were formed into nations. They've been there for over 10,000 years. There were 50 languages spoken in what they ethnoculturally saw as 11 language families. Again, the Aboriginal cultures were diverse as their languages, and this is a really important point, and it's in your text. When you think of Indigenous Canadians, right, and we talk about things like systemic racism, what have you, the dominant thinking these days is that being Indigenous is not being a member of a race, but a member of a culture, and all those things that belong to a culture. All right, so it's not a racial color of your skin kind of thing. So that's an important distinction to remember. Aboriginal cultures are not homogenous, and that's a really important point too, because for white society, and this is a fairly common perception even today, is that when white people or non-Indigenous people, let's say, think about Indigenous peoples, they think of them as a homogenous group. They're Indigenous. They're that 5 or 6% of our population now. It's fast growing. They're that percentage of our population. They believe in Mother Earth. They believe in the Creator. They believe in their language. Maybe it's the same language. We don't know. They believe, they're all kind of the same, right? That's an homogenous society. It's not that way at all. Indigenous cultures, around the world are no more similar to each other than are, white cultures or European cultures, the Spanish, the French, the British, the Germans, the Polish, they're all very, very different, and they're not homogenous by any means. They're heterogeneous, and that's what Indigenous peoples are as well. So it's important to keep that in mind, because, and you think about this, when the British and then the Canadian governments were negotiating treaties, the people who were doing the negotiation, right, had to recognize the difference between this particular tribe or nation and that one when they were negotiating what was important to them to get them to sign away their land, essentially, to convince them that a treaty was a good idea. Indigenous societies, for the most part, again, it's not 100%, but this, for the most part, is an oral tradition, right? That's what the culture is based upon. So it passes stories from one generation to the next. Storytellers are incredibly important. Elders are incredibly important for the purposes of passing that generational knowledge down. When we talk about residential schools, we'll talk about cultural genocide, which deals with this very particularly, how the intergenerational flow of values was destroyed in residential schools, where young children did not have the benefit of learning from their parents or from their grandparents any longer because they were put into a white man's school, right? Incredibly devastating. And the definition of cultural genocide, and it dealt with the destruction of the oral tradition, right? So that's incredibly important to keep in mind. And we'll get there in a couple of weeks. Aboriginal peoples have creation stories. We as the white society have creation stories. They have creation stories. Their stories are different than ours. Again, ours in the most part, Christian society is based upon the Bible, but we do believe in scientific evolution, basically. But we have indigenous creation stories that believe in the creator. They believe in the teachings of the seven grandfathers, right? All kinds of things that are alien to what the dominant society believes in, but are of course incredibly important to the culture of being indigenous. Animals are incredibly important. Other natural elements are incredibly important, and they stand for things. And that's again part of the oral tradition. Intrinsic to the Aboriginal worldview is the connection to the land. The land is a sacred living entity. Really, really interesting, and you saw that in the video, Colonization Road, where he talked about there wasn't enough real estate on the conveyor belt in the grocery store, as in indigenous peoples don't have interest in land to a great degree in this country. It's changing. It's changing as a function of what are called comprehensive land claims agreements, which are also called modern treaties. We'll talk about that later. But when the British and then the Canadians negotiated the initial treaties that we had in place, we're going to talk about those tonight, and the numbered treaties that covered most of the country. When they negotiated those treaties, it was without a question the acquisition of land for the purposes of Canadian settlement, right, and the dispossession of lands of Aboriginal peoples, taking away what we saw as an ownership concept. Not that they saw it that way, but we did. We took away their possibility of ownership and put them on reserves, which only gave them a possessory right, the right to actually live on the reserve, but to not own it. Okay, the Crown still owns reserve lands. All right, Indigenous communities believe in communal groups. They're a collectivist society, right, which means that they tend to agree on things together for the benefit of the group as a whole. It's also why it's important in Indigenous families to take care of their elders within their family, right? That's not what European society does, right? And I'll use that as a metaphor or a synonym for white society. So European society, isn't based upon that collectivism. It's based upon individuality, right? How to get ahead, how to make money, how to have basically a focused, family, and not a extended family, right? So it's not a normal practice. That's again a generalization, but it's not the standard practice in European societies, or at least in white societies of a British descent in this country, to ensure that your parents and grandparents are looked after by living with you when you're adults. Right? What does the white society or the European society do with parents and grandparents who can't take care of themselves and you don't want to take care of them? We put them in care facilities, right? And we know what a problem that's been in the pandemic. All right. At the time of contact, clearly, and again, we'll go into this in a little more detail, Aboriginal nations were seen as nations themselves. They were seen that way in the international context. So anybody dealing with them was on a nation-to-nation basis, right? Not on any kind of a dominant, subservient basis. Right? That's important to remember, basically. So at contact, what we had, we're talking about white contact. Originally, we had Vikings coming from Scandinavia and Greenland to Newfoundland, right, for fishing in 1497, and in less than 100 years, they had already documented over 400 ships coming. So that's not by any means a lot, but it was the beginning of colonization to a great degree, although it certainly wasn't considered to be colonization at the time. Jacques Cartier basically came down the St. Lawrence in the 14th century, mid 1500s, all right, and he brought with him French priests. So the Catholic Church was incredibly influential with the development of settlement in this country when it was done by the French in the 1500s. Right? There's a film that in the trade relations course that I teach, I started off with a film called The Black Robe. It's a Canadian film. It's very, very well done. It talks about exactly that, about how French priests try to civilize again, the savage, in the country that they found themselves in. We had a covenant chain. It was referenced in the video as well. That was Pam Palmatier. She's a prof at Ryerson. I know Pam. She's incredibly smart. She's Indigenous. She's their lead Indigenous scholar at Ryerson. There was a covenant chain between the British and Indigenous peoples, the two-row wampum belt, right, which was two separate rows, basically that indicated that the Indigenous peoples and the white peoples, or British at the time, originally French, would coexist together, not run over each other, not overtake each other, but would coexist. And there's on that two-row wampum belt, there's a ship, that you can see that sails along, right, which is a metaphor for basically, free sailing, without trouble going forward. Okay, so there are three periods that we can talk about with respect to the treatment of Indigenous Canadians or Indigenous persons that become Canadians in this country. There's the initial period of 1500 to 1815, then which is at the end of the War of 1814, 1812. There is then that next period to Confederation, 7, and then from 1867 going forward. All right, so when white men came to North America, this is the time of contact. Clearly what they intended to do was they came here, they were enormously outnumbered by Indigenous Canadians. So, the first people who came here, whether it was priests or traders or hunters, they had no expectation of becoming a dominant society. That was not what they expected to do when they first came here, because simply the numbers, they were facing tens of thousands of Indigenous peoples, versus a handful of Europeans. So they came here for the benefit of peace, and they had alliances and commerce by setting up things like trading posts and what have you to collect goods and wares, and then take those and ship them back to either France or England to make a living on it, right? They became hunters and trappers. There was no indication whatsoever in the early documentation that the parties did not treat each other as anything other than equals, right? Historians basically look at this period of time and clearly indicate that Indigenous peoples had their sovereignty over the lands they occupied, which is essentially the entire country, right? So they had sovereignty. There was nothing to displace that sovereignty when contact first took place. All right, they recognize, again, the historians recognize the presence of an organized society, right? It was a society that could certainly push back against any foreign power trying to acquire it, at least at the beginning, right? And there was also no doctrine of occupation, right, of these lands by those from Europe. So there was no support from the French or later, more importantly, the British for the concept of terra nullius, right? Anybody want to talk about terra nullius? If you've been in any one of my previous classes, you can tell us what that is. It's an important concept because it still exists to some degree. All right, so terra nullius was a concept that when the British, we'll say the French abandoned North America to a great degree in 1760. So the British did not impose the concept of terra nullius, which means they didn't come to North America. Remember, in the 1600s, it was North America. It wasn't the US or Canada, it was North America. They didn't come here and look out on the vista or the horizon and said, we don't recognize these peoples who are here. They don't exist, so this is our land, right? We don't recognize it as being a no man's land, right? That's a really interesting concept because that was the way things started out. Because in Australia, at the same time, again, a parallel British colonial government going into place, they did exactly the opposite. They built that country on the premise of terra nullius, right? And that's how they treated their Indigenous peoples, fundamentally different than we did on that premise. And Australia did not have its first treaty with an Indigenous tribe until 1992. And it was only with a very small nation off an island off the north of Australia, right? It's only now in the last 10 years that the states, and the country as a whole, it's a federated country, they are looking at negotiating treaties with Indigenous peoples, right? Australia, the British settlement of Australia was totally different than Canada. And honest to God, I don't know why, because it was the same British government, the exact same people in London who were administering what was going on in North America and at the same time, Australia. Anyway, that's really interesting. Anyway, having said that, so, again, at the beginning, treaties were often negotiated with a military dimension to them because that was really important, particularly during the time that the English and French were still fighting each other, not only in Europe, but fighting each other in North America over the fur trade and commerce for the most part in North America. Right? So, it is important when you entered into friendship treaties with a particular tribe that it included a military component so that if you were British, you could count on whatever tribe you had negotiated with to help you fight against the French and whatever tribe they had enlisted, right? So Indigenous peoples had considerable military value because they knew how to fight. They fought themselves. Again, they weren't homogenous. They knew how to fight, particularly in this country. They knew where to hide, how to fight in forests. They knew what to do in order to win military battles. So they were incredibly important, obviously. So they were adept at war tactics, and that's why they had such value, right? Again, the law that applied, before anything was imposed was public international law, which means that the Indigenous peoples were on equal footing with the Europeans, right? Which is saying if you think about that, that really, that sounds like a good thing because it sounds like, well, the British or the French didn't say they had a superior way of life or a way of government over them. You have to remember that they were, the British and the French were a very, very small cohort of people, right? So for the public international law to recognize that they were equal with the tens of thousands of Aboriginal peoples who were here is really not a put down of the white Europeans. It's putting them on a pedestal. They were given a lot more credit for being equal to the thousands or millions of Indigenous peoples already here. So keep that in mind. But having said that, they were both considered to be sovereign. And they treat each other. However, all right, and we're moving through time now, as treaties became dominated by land cession, which means acquisition of land, and that wasn't part of the friendship and military alliances. That wasn't part of those initial treaties. But once it started to become part of the equation, now originally the French, but after 1760, the British took it into their heads that, we want to acquire land for settlement, to house those people who are here with our armies, to develop the commerce. We want people to actually own their own land because that's what our society is built upon. Again, John Locke, British society, European society does value land ownership, and so does Canadian society today, right? So that what they did is basically when they started to think about, well, treaties should be more than just friendship and alliance and trading. They need to now start thinking about acquiring lands and territories. So once that started happening, right, the concept of the sovereign nation started to fall away. The concept of the nation-to-nation dialogue started to fall away. And the concept that these Indigenous peoples had their own societies started to be melded into the European concept of law, European law, right? Because land ownership is a function of European law. All right. So as a function of that, what happened is the colonists, these are now the people who have decided to live here and to create colonies, cities and towns to grow, in North America. What they started doing is, instead of thinking of treaties as international treaties, the way nation-to-nation treaties were looked at previously, they started to consider them to be simply contracts under colonial law. Again, very much contract law is a British common law, right? With the expansion of the need again for settlement, the acquisition of land for farming and what have you, right? Then, the territorial needs of the colonists started to conflict with everybody who's already here. Clearly, how is that not going to happen? You're dealing with every square inch of this continent being occupied to a great degree by an Indigenous person, now needing to displace them in order to acquire the lands that they occupied, right? However, right, and this is now the 1700s, we've gone from in the 1800s and what have you, we're now looking at basically the creation of North America. And, the ability to acquire lands and not to do it by conquest. Right, so now we're gonna leave the United States behind because they had their manifest destiny was one of conquest. We're now going to look at Canada in the 1800s, basically, who looked at, if we are going to, build this new country again, Johnny MacDonald and the boys, if we're going to build this new country, we should be doing it basically by, acquiring these lands and not, stealing them or that kind of nature, right? So what happened is that the purchases of lands were centralized with the colonial government rather than individuals. So the whole purpose of that was that colonizers did not, the power of them to individually acquire land by basically cheating Indigenous peoples out of their lands was diminished, right? And we're going to get to the proclamation in this regard. And the requirement of purchase of Indigenous lands basically was an acknowledgement that they now had legal rights under English property law, right? So now we've basically transformed society in which the Europeans came, right, from the international concepts that we described into the English legal system, right? And that's obviously what we have today as well, right? And what that became known as, the fact that individual colonists couldn't buy Indigenous lands on their own, became known as the inalienability of Aboriginal title, right? And all of that was a function, Michelle, all of that was a function of the Royal Proclamation of 1763, all right? So the Royal Proclamation of 1763 came about at the end of the 7 Years' War between Britain and France, which ended in 1760. At that point, France basically gave up its desire to own large swaths of land in British North America. So it gave it to the British with the exception of Louisiana and 2 islands in the Maritimes, St. Pierre and Miquelon. Right, so the French said to the British, here, you take it, right? And this is a function of a treaty they signed in Paris, actually, right? And it's a function of that. What we were left with, what the British government was, remember, we're talking about politicians in London, what they were left with was, oh, okay, well, thank you, all right? We now have North America, it's all ours, we don't have to worry about fighting for it any longer, at least with the French, but we have to administer it, right? We just can't, leave it as it is. We have to put in some kind of form of political organization to make sure that it runs efficiently. The British pride themselves in efficiency, that it runs according to English law, right? That's been indoctrinated now. And it does for us what we wanted to do, which is to a great degree generate money. All right, so as a function of that, the British no longer needed military alliances with tribes, right? So there was no need to have tribes with that as part of their nature any longer. There is no need to buy them off with gifts to entice them into treaties for that purpose, right? And they no longer needed to compete for commerce with the French, and that was really important in the trading posts because the trading posts were split between the French and the British, and as a function of the Hudson's Bay Company. And the Hudson's Bay Company, after the 1760s, totally dominated trading in certainly north part of North America, right? However, having said that, there's a Chief Pontiac in the northern U.S. states who was unhappy with the way that the colonizers were treating them, notwithstanding the Royal Proclamation, and I'll give you the details of that in a second, led to a revolt, and that revolt got the attention of politicians in London who basically said, whoa, we have to do something here to fix this. And that brought about, by way of the Imperial Parliament, having King George III give the Royal Proclamation declaring how Indigenous peoples in North America would be treated. All right, remember it's 1763, so the United States hasn't declared independence yet. So we're talking about a tremendous amount of territory in North America. We're talking about the United States, what was then the 13 colonies, and the 4 colonies that was Canada at the time, together with all the other parts of North America that was at the time called Indian Territory. All right. So what the Royal Proclamation did, now King George is given credit for it, but King George had only been on the throne for a couple of years. By 1763, he was still a young man. He didn't really, while it was in his name because he has to sign all these kind of things, all laws, proclamations, while it was referred to as King George III's Royal Proclamation, It was clearly done by the British Parliament, right? The Imperial Parliament sitting in London. So what its intent was at the time, now that France had left and England basically said, well, now we have to figure out how to run North America now that it's all ours. So what the Royal Proclamation did is it basically said, look, this is how we're going to treat, the colonial occupants of British North America, and we're going to treat the indigenous peoples that live with them, right? And so what it ended up being considered was now the principal source of law relating to territorial rights of indigenous peoples today, right? Based on 1763, right? And the proclamation was just that. It was a proclamation, and that's not a treaty. That's not a contract. That's not even, that's nothing other than the British government through the king saying, this is what the law is in North America. This is what it is. There was no voting for it, in North America. Nobody in North America had any input into it. This is what North America is going to look like. But they also recognized at the time that they still had these tens of thousands of people to deal with who were indigenous. So what they did is they brought everybody together. They brought 2,000 chiefs together in Niagara in 1764, and they incorporated the terms of the Royal Proclamation of 1763 into what's called the Treaty of Niagara of 1764, which is still the law. It's still a valid treaty today. All right? It did two things. It froze colonization of North America, which was in response to Pontiac's revolt, right? And the helter-skelter way that North America was developing without a colonial British government ruling the entire continent, right? So it stopped temporarily colonization to the west, which was a tremendous swath of land, apart from the colonies that already existed. And importantly, and this is the inalienability of Aboriginal rights requirement, basically the Crown was the only party that could purchase indigenous lands. And that is still the law today. Okay, we're going to get into that, right? So what the king did basically is it reserved all of the other lands outside of the colonies as Indian territory. So it was bordered by the Appalachians, which is a mountain range to the northeast, by Quebec, and by Rupert's Land, which was basically northern Ontario, Manitoba, Saskatchewan, big chunk of Alberta, and the territories at the time. That was Rupert's Land, run by Hudson's Bay Company, right? And from there all the way down to Florida. So a tremendous amount of territory. And that was considered to be Indian territory. So basically the proclamation clearly said that there will not be any colonization of that territory, right, unless the government, the British government, decides otherwise. It was a temporary freeze, hence the word temporary. So it was lifted, but that's what happened in 1763 to basically allow the British government to reset, how the political structure and laws in North America were going to go forward, right? By reserving lands not purchased by the Crown to indigenous peoples, it recognized pre-existing Aboriginal rights to their lands, to possess them, and in the British way of thinking, to own them, although ownership is not an Aboriginal concept, right? And that ownership of those lands could only be acquired by the way of acquisition of the title, right? So by way of the extinguishment by cession, C-E-S-S-I-O-N. That's really means legal acquisition of title, all right? The provision that only the Crown can acquire land is now in the Indian Act of 1876. So that's why I said it's still the law of Canada, right? So 1876 is when the Indian Act, basically a century after the proclamation, codified all of the indigenous laws, both in the proclamation and those that had taken place prior to its enactment, right? The proclamation does not profess that indigenous peoples are self-governing, right? So it didn't go down that road. It didn't try to say in any size or shape or form, here's what indigenous government should look like, or indigenous political structures should look like, right? So it didn't create self-governance. It also didn't say that it didn't have the right to have its own governance. Okay, that's important, right? So the Crown did not intend to change indigenous political systems, the tribal systems, whatever were in place, in the Indian territory at that time, right? So that's a pretty open kind of way to look at it, right? It's argued that the presentation of the proclamation of indigenous peoples at the Treaty of 1764 for their approval turned it into a treaty between nations, right? And that's a very broad determination. So now we're back to treating Indigenous peoples as a nation-to-nation negotiation, right? So that's a really important consideration, right? The Royal Proclamation is still in effect. This is a video I put up here for you by it's now by Senator Murray Sinclair. He's retiring from the Senate like now or in the last couple of weeks. Murray Sinclair is an incredibly influential Indigenous leader in Canada. He was the first judge of a court of law in Manitoba who is Indigenous, and he was appointed a judge at first of the provincial court and then the Court of Queen's Bench. And from there, he became a senator, and he was also appointed by Stephen Harper as the chair of the Truth and Reconciliation Commission. So he chaired that entire process together with the recommendations that came out of it a couple of years ago. We'll talk about that in another class. So I'm going to leave this, it's half an hour long, so we're not going to watch it tonight. I'm going to leave it for you to watch. But what it is Murray Sinclair talking about the Royal Proclamation as the Indian Bill of Rights. That's the way he describes it. Okay. After the War of 1812 between Britain and America, right? So they stopped fighting the French, but then turned to fight the Americans after their independence. Again, they stopped the impetus to treat Indigenous peoples as nation to nation. They no longer again needed them for military alliance, right? And so the power started to shift from alliances with Indigenous peoples to now the power coalescing in the colonists, right? After 1815, basically, after the war with the States was done, the British basically took it into heart to say, now we're going to colonize, what was Indian territory. We're now going to move forward and create a white British nation. Remember, that's Canada, because the US was now a country of its own. From the 1800s, courts again started to rule. The Indigenous peoples were a distinct race, back to that concept, without self-government and in need of guardianship, right? Which became not only racial, but a cultural attitude, which created paternalism. Paternalism is something that we still see today. Paternalism again, is white people in North America looking at the Indigenous peoples of whatever tribe they belong to become First Nations and seeing them as inferior, right? Seeing the white dominant culture, not race necessarily, but culture, as being dominant, and seeing that the benefits of Western civilization should be imposed upon these peoples who did not have the benefit of being British or white, right? There was widespread intermingling. We talked about this last day. Again, Hudson's Bay Company did it, as a policy to get out and, co-mingle with Indigenous women as widely and as much as you can, right? And you created, the Métis Nation, across the country and in the US too, but created the Métis Nation to a great degree a function of Scottish traders and trappers with Indigenous women. Right, the guy who did the video that we watched, Coronation Road, I've forgotten his name, but it's a Scottish name. And people, if you look at the names who were interviewed, they're also Scottish names, start with MC, MAC, MCL, right? So there's a lot of Métis that have those roots, obviously. And this was a policy. So again, it's a function of intermingling. So we're going to reduce, the presence of these people, as a people themselves in this country going forward. International law also changed. It stopped looking at Indigenous peoples from a nation-to-nation basis and looked at international law only applying from nation to nation if they were civilized states, one to each other, right? And Indigenous peoples were not seen as a civilized state, so they no longer had the protection of international law. And they lost protection of international law, right? And that's other lecture. It then turned to, while terra nullius was not something that was here at contact, it's a concept that started to creep into colonization, right? That in some places, it became easier for the white colonizers to look at the territory that they wanted to colonize and say, this is ours. We don't have to negotiate for it. It's just going to be ours as a function of us being here. We don't recognize these people as being a people with any rights on these lands, right? And that to a great degree sped up colonization. It reduced the amount of money that had to be spent for the purposes of treaty acquisition, territory, and what have you. Basically, So it fed into their own political structure, right? Now, a confederation with the British North America Act, Indigenous peoples were considered to be mere subjects, subject to Section 9124, which we went into at length last day. So there was no discussion in 1867 with Indigenous peoples and how they fit into the Constitution. Very little of it in 1982, but none of it in 1867. So these Indigenous peoples, right, with no impact or impart whatsoever, became British subjects, right, by virtue of a constitutional document that they had nothing to do with, right? At the time of Confederation, we had Ontario, Quebec, Nova Scotia, New Brunswick. Those were the 4 colonies. Rupert's Land, owned by the Hudson's Bay Company, right? 1871, British Columbia joined. British Columbia is the major provincial jurisdiction in this country that adopted terra nullius as this policy, right? So when British Columbia became a province in Confederation, it did not recognize the ownership rights of Indigenous peoples in its territory. That's terra nullius. And it therefore did not negotiate any treaties with Indigenous peoples when it became a province. It just assumed all the land, right? And trust me, and we'll see this during the semester, it has come back to bite them big time, because now, British Columbia is subject to negotiating treaties, what are called comprehensive land claims, for wide areas of lands, at today's monetary value, right? So it's really come back to bite them, and we'll talk about that in another class, right? In 1870, Rupert's Land became the Northwest Territories, part of Canada, basically. Just prior to that, Northwest Territories, created Manitoba. That was a function of negotiations with Louis Riel and on behalf of the Métis. We talked about that last day, right? Again, the Métis were on a different basis than other Indigenous peoples regarding the acquisition of lands, right? And we touched on this last day. They were seen as, as more white than Indigenous at the time. In fact, so Métis were given the right to acquire lands, right? So, and they were actually quite poor lands, but they still were given the rights for land ownership, which was not given to people who didn't have that white element in their quantum, their blood quantum, right? So Métis, for the most part, did not have a reserve system, and they're not First Nation, so without a treaty, so they don't have that in place. They have Métis nations across large swaths of land that they consider to be their territory, right? Those lands, for Métis ownership, were chosen by the government, right? There was no options in what to pick, and they were put in extremely remote and very, very non-arable lands. So farming was incredibly difficult, right? To assist with the settlement west, the policy of purchasing Indigenous lands basically took over, right? So in fact, the negotiated treaties became incredibly important, and the Europeans, the British now after 1760, realized that they could acquire these lands in return for money, right? So currency was recognized by Indigenous peoples, obviously, and European goods, and that led to the creation of reserves, right? And so what this is historians basically said is, Indigenous peoples recognized that they really couldn't turn back what was now becoming, now we're talking about the mid 1800s, the 19th century. They couldn't really turn back the vast numbers of Europeans coming to the shores, right? The British, the French, and in the United States, the Americans, previously the British, they couldn't see turning it back. There was no way they were returning to their prior lives of a peaceful coexistence on the land. They knew that they would have to negotiate with these settlers, these colonizers going forward, right? So their way of life was going to disappear for the most part, and they saw that coming, right? So what happened was that, in the 1850s, there was some skirmishes with respect to Indigenous rights and territories, exactly where we are in Sault Ste. Marie and the territory. And so what happened was that a commissioner by the name of Robinson was appointed to settle the land issues with the Indigenous peoples in these areas. So what happened in 1850 was the negotiation of the Robinson-Huron and the Robinson-Superior treaties, right? So these were the first widely recognized templates for treaties in Canada, right? So this territory you see here in the brown gold kind of color, that's Robinson-Huron, right? And First Nations are in these red dots, okay? So Robinson-Huron has Batchewana and Garden River, okay? And Sault Ste. Marie is in and on the Robinson-Huron Treaty lands, okay? And then going north from Robinson-Huron is the Robinson-Superior Treaty, which goes all the way along the northern shore of Lake Superior around includes Thunder Bay and down, heading further to the west. Okay. In Manitoba, and again, we talked about this last day a bit, Indigenous peoples started to turn back settlers, right? And this is the Métis Nation to the great degree, and Indigenous peoples. And so, the federal government decided that, they had to try to now negotiate treaties. There was no way, they realized, that they're going to be able to colonize without treaties for the rest of the country. They're going to basically have to enter into treaties for the rest of the country, essentially, for the most part. Again, didn't include British Columbia. But so what they did is they created what are called 11 numbered treaties. And that's what they are here. So you can see, it's this in Ontario is north of the Robinson Superior Huron treaties. That's Ontario, and here you have Manitoba, Saskatchewan, Alberta, the northern part of British Columbia, but all of this terra nullius, no treaties. Okay, so and then obviously these other parts of the country that aren't part of the number treaties, but they've now been what are called modern treaties, and we'll get to that, right? So those treaties basically contain now, for the first time, the acquisition or the cession of Indigenous territory, right? So again, we talked about this is now treaties going from being no longer of a military or a commercial basis to being one where colonists were acquiring lands for territorial expansion. So, Indigenous peoples had a territory, right? A large territory that became Indigenous territory that now the British colonial government had to negotiate with. And so what they negotiated with the Indigenous people was, look, you can have reserves on these predetermined areas. We'll call them reserves, and that's what they are. You will live there. You have the right to live there. You have the right to, build whatever housing on there that you want, and what have you. And the rest of your territory will become Crown land. And we can do with that pretty much what we will. But you still have the right to hunt and trap on it. But it's still Crown land. So it belongs to, firstly, the government of Canada, and then became the province of Ontario, and and all the provinces and the federal government negotiated that Crown land accordingly, right? And that's the way they were, and that happened across the country. So Robinson Huron, Robinson Superior, and then those 11 great numbered treaties did all the same thing. So people were put on reserves, right, where they would stay basically. Again, they were still allowed to hunt, trap, and fish on and off the reserves. They were provided with an annuity. Now that says $5, but I know that the Robinson Huron Treaty annuity was $4, right? It still is $4. So it was $4 in 1850. It's my son-in-law still gets $4 once a year from Batchewana. Humongous, importantly famous trial recently. It was hit the trial in 2017. Ruled that the federal government and the provincial government basically breached its terms of its annuity with all of the members of the Robinson Huron Treaty, the Indigenous members, with that $4, because the $4 was supposed to also go up every year as a reflection of the minerals that were mined in the territory, and it didn't. So there's a trial a couple of years ago held that the federal and provincial governments owe all of the descendants, basically, of the Indigenous peoples in Robinson Huron that increased annuity from 1850 going forward. It's now in the stage where the courts are trying to figure out how much that's worth, right? I couldn't tell my son-in-law that he could buy a new car from whatever he's going to get, because there's 50,000 people who are going to partake in that annuity distribution, but it's still going to be a chunk, right? And that's still ongoing. And again, we'll talk about that in the class on lands and treaties. All right. Again, the government, first the British, then the Canadian, saw this as classic property transactions. So again, it was the acquisition of title with the transfer of title and Crown land, that's registered for every piece of property in the province, basically, in the country for that matter, right? Indigenous peoples didn't see it that way. That's not their concept of ownership. They saw these agreements as agreements to share the land and not necessarily transferring over a unilateral appropriation of title, but in fact, that's what they did. They didn't understand the concept of private property and ownership, and even though they did have, some had translators when they entered into these treaties, they weren't necessarily told, what these concepts meant. Matter of fact, I'm sure they weren't told these concepts meant, because they wouldn't understand them to begin with, and nobody made an effort to try to teach them that you are actually now giving up the right to what English consider an ownership concept. The treaties were verbal. Later, they were written down, but they didn't necessarily find their way word for word into the written text, basically. Large-scale treaty making ended in 1930, so that's the end of the 11 treaties, right? The Canadian government at that time stopped dealing with the treaties. They decided that they didn't have to deal with Indigenous peoples anymore. So in this modern era, there was a turning against Indigenous rights to a great degree. The the Indian Act was incredibly discriminatory and maintained being discriminatory from 1876 up until relatively recently. So at the beginning of the 20th century, the Canadian government, again fundamentally a British government, did not respect Indigenous rights by any means. Basically, still several parts of Canada were not ceded during this time. That's all of the Yukon, good part of the Northwest Territories, the north half of Quebec, and of course British Columbia. The south of Quebec and the Maritimes did not see themselves as needing treaties because they were settled by the French, and the French didn't recognize Indigenous rights, so there was terra nullius there as well. Okay, in 1845, the issue became so difficult for colonization, and there still was colonization taking place in the Western provinces, that the imperial government basically created what's called the Bagot Commission to look into it. How can we fix what's going on, which basically means how can we make things better for the British in Canada as opposed to the Indigenous, basically. And what they decided to do was to civilize Indigenous peoples and educate them in Western ways. And they had already, and this is back in the early 1800s, they created the residential school system, and we're going to have an entire class on that. Okay, so again, that is the British imposing their values on these peoples that they saw as inferior, and they saw that as the way to colonize this country. They also looked at removing the annual distribution of gifts and everything else that was connected with the Royal Proclamation. So they were rescinding what they'd originally agreed to. All of the laws, including the proclamation, were coalesced in 1876 into the Indian Act, and the Indian Act still exists, right? Only to be replaced in the future by whatever happens with Section 35 of the Constitution. I touched on that last day. We'll talk about that again, right? So the Indian Act confirmed the establishment of reserves. It confirmed the principle that Indian lands, Indian territory could still only be acquired by the government and not individuals, right? However, having said that, colonists still went out and improperly acquired lands, and when it went to court, basically the courts upheld colonizers owning that title and paying Indigenous peoples a very small sum in return for that. So that was just a way to try to get around the inalienability of lands, basically. Contrary to the proclamation and recognition that people had their own political structure, what the Indian Act has done is created its own system. So band councils for First Nations, most of you probably don't know this, but that's a white man's term. So Indian bands are a white man's creation. That was a form of political structure put in place by the colonial government for the political organization of Indigenous peoples on reserves, right? So people were, the treaties were negotiated, the reserves were created, people were put onto the reserves, and they said, and now that you're on these reserves, you're going to, we want you to elect a band council to report to us, the Indian agent, basically the federal representative, report to us what you're doing, and we'll tell you what you in fact can do. And if they didn't put a band council in place, the federal government would put one in place, arbitrarily. All right. Indian Act created the blood quantum of status, section 6.1 and 6.2. So we know all about that. You guys are very familiar with that. That's a good thing, obviously, to know that. That was the Indian Act, and it still exists, right? Losing status would mean the loss of the right to live on the reserve. You couldn't inherit land from family, or you couldn't inherit anything of a property nature of things that were on reserve, didn't own the land. There was no tax exemptions for federal taxation, no annuities any longer if you lost your status, basically. In 1951, a central registry was created by the federal government. This was a way to keep control over Indigenous peoples in Canada by essentially putting them all down in a registry, naming them, so they had a record of them, and they could use that record to keep track of Indigenous peoples in Canada, right? And that's still a registry that exists, right? There was discrimination to women, so a status woman, and I talked about this last day, who married a non-status man, lost her status, as did her children. In the case of divorce from a non-status man, she could not return to the reserve, right? That's a highly gender-specific discriminatory practice. a status man marrying a non-status woman gave status to the woman, right? So that was obviously a very much a gender discriminatory practice that was repealed in 1985. But as I talked about 2 classes ago, there was the double grandparent rule that was in effect that just was remedied last year, essentially, dealing with how status would go down through women, basically. The policy of enfranchisement was there, and this was a policy to basically take someone who had status and have that status removed, not because they were being disenfranchised, but because they were being enfranchised into being a white person, right? Enfranchisement is gaining a benefit, not losing one, right? And so for decades, the Indian Act's purpose was to, again, assimilate Indigenous peoples into the Canadian fabric by taking away their status, or by voluntarily having Indigenous peoples lose their status to become more white, right? And so again, things like, if you obtained a university degree, you became enfranchised, or you became a member of the armed forces, you became enfranchised, you became a member of the clergy, you became enfranchised, those kind of things, right? For a very, very long period of time on reserves, they were totally at the hands of the Indian agents, which meant that they had a pass system, which means you could not leave the reserve unless you had a piece of paper, a script from the Indian agent giving you permission to leave, right? You couldn't have a last will and testament approved without the Indian agent giving his consent to it, right? And it was only up until the 1960s, very, very many Indigenous people did not have the right to vote in Canada, and nobody had a voter right in Quebec until the 1960s if you're an Indigenous person. Okay, all right, guys, so that's governance. Man, that's a lot, and I keep telling you that I'm gonna let you early, and I keep talking, so I apologize for that, but there's just so much of this material to handle. I guarantee you the classes dealing with the subject-specific things like residential schools and family violence and what have you won't be these marathons of lectures, so that won't happen. All right, so what we're gonna do now is I'm going to put everybody into the breakout rooms. Again, same thing as last day. I'm going to put you into 5 rooms. There are 5 questions. I'll give you 10 minutes to answer the questions, and then I'll bring you all back out to basically give your answers to the rest of the class, and then we'll call it a night. All right, guys. So there'll be 5 breakout rooms.